As soon as one other senator walks in the door, we're going to have a quorum. We have a brand new member I want to introduce to you. I'll let him introduce himself and tell us where he's from. Senator Dugan. Which mic are you?
7.
If you'll introduce yourself and open us up in a word of prayer, please.
Okay, I'm Mike Dugan. I'm here because I got asked to carry a bill for somebody else who was carrying it for somebody else. All you got to do is come and ask for one thing, and you're out of here. Next thing I know, I'm on the committee and doing the invocation.
I don't want to cut you off, but we actually don't need you anymore. No, but please stay. We may.
Yes, if you would bow with me. Lord, help us. We need all the help we can, especially at this time of the session. I just want to close with what we should ask every day. Give us the wisdom to do what's right, but always the compassion to do what's good. In your name we pray. Amen.
Man, it's a great prayer. Thank you for being so flexible with us. And you can really, are you leaving? Well, we might. Okay, it's your call. All right, that was quick. You're more like our chaplain today, I guess. Yeah. No, he was so good. I'm going to start with his bill. So we are going to probably somewhat go out of order, and we'll stick with the agenda, but we're going to look at who's in the room. The House is in session right now. We want to make sure they can keep passing Senate bills, so we're going to be flexible with our House members that are here. As always, if you want to speak on a bill, please come sign up. We're collecting the sign-up sheets. Come up here and see us if you forgot to sign up or need to. And we're going to start, and give us some time because I have a lot of bills. We're going to have to sort through our folders. We're going to start with House Bill 243. And we're working off substitute LC 442362S. Give us just 1 second. And our House sponsor is with the governor. And I guess he takes priority over this committee. But I will let the senator that has part of the Coweta Judicial Circuit, Senator Dugan, floor is yours.
Thank you, Mr. Chairman, members of the committee. We want to add another judge to the Coweta Circuit. Any questions?
You would have been a good committee member. I wish you'd stick around. The only, any questions from the committee? Nobody signed up to speak.
Okay.
We've already approved 2 different Superior Court judges this year, and historically that's about all we do in a year. I just wondered if the Superior Court Council of Superior Court Judges has a specific need here, or where this falls in the pecking order, the ranking order as to need.
Senator, I'm going to turn that over to my counsel.
That'd be great.
I know you're in the top 3, and it's in the current draft of the budget. Do you know what number Coweta is?
We're in the top 3, is my understanding.
3?
Wait,
2.
okay, top 2. That's even better. We've got a 5-county circuit, Senator, and so you look at the case loads in these counties, and they are tremendous. And with the backlog that we have, even before then, there was a need for this additional Superior Court judge. So if we didn't need it, we sure wouldn't ask for it, because we know that's increased burden on the taxpayer. But this will help make sure that the adjudication of these cases is carried out in a swifter fashion.
Thank you.
Don't go anywhere. For the last decade, since Representative, now Judge Hightower, was in the House, we've been authorized to have an increase. We've just now come to the point where we're really, really asking for one.
All right. The substitute, and I will confirm my judicial council folks, substitute has some changes in the dates from the House version. We're making sure with the current draft of the budget, and I've confirmed this with the House leadership this morning, with all 3 of our judgeship bills, they're being moved to January 1st, 2024. That's when the new judge will start. When you do that, you have to also adjust the terms with these other dates. And the draft we have, you'll see, has December 31st, 2026 as the initial term. Then you have an election in 2026, and then the 4-year term after the election will be starting January 1st, 2027. And so we have all that in this sub. And we are also working across both chambers to make these 3 bills all say that. This is the only one so far that says that. Any questions from the committee? Any other questions? Anybody, no one else signed to speak on the bill. What's the pleasure of the committee? Move to pass from Senator Sessler by committee substitute. Is there a second? Second from Senator Hatchett. Any discussion? All those in favor of the motion, please say aye. Aye. Any noes, like sign. It is unanimous. And who's carrying this one in the
I think
Senate?
it's the rules chair.
Senator Brass is carrying it. Chairman Brass, you're correct. All right.
Okay.
Thank you. Appreciate you. All right, let's go back on the agenda at the top then. House Bill 227, Representative Leverett. We are working off a committee substitute, LC 4808. Oh, pause for 1 second. Let me correct myself. As Scott said, I say committee substitute. That's just the House language. This is not a committee substitute. Working off LC 480871S, and this is as passed by the House. Is that right, Representative?
That's correct,
Okay.
Mr. Chairman.
Thank you. All right, the floor is yours.
Thank you, Mr. Chairman. It's good to be back with you again. As I was telling the chairman, this has sort of become my home away from home here during the second part of the session. I think 6 bills have been assigned to this committee, and I appreciate your consideration of them. House Bill 227 was passed to address a very troubling trend and a grave concern that I know you've all observed, which is increasing attacks on our critical infrastructure, on utilities, not just on property owned by utilities that has a very limited scope, but on property that serves a broad range of citizens and people, and the damage to which can become devastating for large areas of people. The attacks, since 2022, the number of direct physical attacks that threaten electrical grid rose to 163. Which is a 77% increase over the previous year, and that's according to data released by the U.S. Energy Department. They occurred across more than 36 states and impacted about 90,000 customers. And most close to home, you will remember the attack in North Carolina that put about 40,000 people without power in one of the coldest snaps that I remember in my lifetime, just drastically affecting a large group of people. So what we're proposing to do in 227 is to take the criminal damage to property in the first degree statute and make a subset of that crime, which is damage to critical infrastructure or vital public service. So the guts of the bill is primarily in Section 2. We add some, we use the critical infrastructure definition from the domestic terrorism statute, and then also define electronic means, public transportation system, and vital public service, and then provide that if you knowingly and without authority, and either by force or violence or by electronic means, interfere with the proper operation of any critical infrastructure or a vital public service, it is also criminal damage to property in the first degree. And instead of the usual 1 to 10 year range, you could be punished by a 2 to 20 year range. So we're trying to give prosecutors an additional tool, so to speak, where they can charge where the damage may not have constituted domestic terrorism. It may not have been to incite terror or for any political goal, but still caused a very broad impact on a lot of people. And one example, there was a situation, I think, in California where someone damaged a substation, but didn't do so to make any political statement. They just did so because it would shut power to a large neighborhoods, and they could go in and rob without having to worry about the burglar alarms being on. So that really doesn't constitute domestic terrorism, but it does have a broader impact, and we felt like there should be a separate crime for that has a heightened penalty because of the scope of the impact the crime would have. And there is an amendment, I think, which would also add railroads to critical infrastructure to make it clear We felt like they were already included, but the railroads wanted to make sure, and we understand that. And then it would also make clear that the definition of vital public service, which is now going to be used in the definition of critical infrastructure, which also appears in the domestic terrorism statute, that definition also appears in that statute as well. So it was just sort of a cleanup, I guess, in a way, that particular issue. So that's the bill, Mr. Chairman.
Is the amendment AM 480027?
I believe so, Mr. Chairman. I actually did not print one, but I'm pretty sure that's it. I believe Chairman
So we
Cowsert has that.
Have in our folder. Okay. Does everybody have the amendment, proposed amendment? Should be the last page of your bill. Are any questions for the author on House Bill 227? Do you have a question from Senator Setzler?
Gentlemen, thank you for this. Is it your intention to include private financial institutions in this?
Well, if they fall within the scope of the definition, yes. For example, I know we've got a lot of public or private financial infrastructure here in the state with the processing of card transactions, and this is intended to catch any attempt to interfere with that system.
Okay. I just want to be clear for committee members. So I'm just asking dumb questions we ask in this committee, right?
Yeah, I'm on House duty. We do that all the time.
Yeah. I just want to make sure we're clear on what we're voting on, because it's just to make I'm not sure I have an issue policy-wise with that. I just want to, because when we talk about debilitating impact on financial security of the public or other services, the loss of which would be, do you think hacking a individual bank where you've got a lot of people who've got their money in there, is it the intention of this to include hacking a bank?
Well, honestly, that was not something specifically in my mind subjectively as we thought about it, but I think it certainly could be included within that definition. Let me just review it again.
I'm on lines 30 through 31. Other service loss of which would have debilitating impact on financial security. I mean,
yeah, I think it could be included. I don't know that absolutely would be. I think that's probably going to be a matter of judicial interpretation, but it is certainly intended to include cyber crimes and attempts to hack into that kind of infrastructure. So it could include an attempt to invade the province of one bank. Of course, private versus public property isn't necessarily a distinguishing factor, because technically most utility is privately owned, even though there's a public interest imbued with it.
I think as long as the committee's cool with that, I think protecting fintech's an important thing in this, because it has a marketplace-wide effect, right? It's privately held, but it's certainly a public interest in that work, and I just want to make sure we understand what we're looking at here. So,
well, thank you for the question. I appreciate you bringing that up.
Any other questions from the committee? All right, nobody has signed up to speak on the bill. We do have the proposed amendment. Let's first see if we have a motion to pass. What's the pleasure of the committee?
Move to pass.
We have a motion to pass by Senator Cowsert. Do we have a second? Second from Senator Watson. You have a proposed amendment in your folder, which is AM 480027, that's supported by the author. Senator Cowsert, do you want to offer the amendment?
This amendment AM 480027.
Do we have a second on the proposed amendment?
Second.
A second from Senator Hatch. Any discussion?
question, what is?
All right, let me turn your mic on. What's your number, 13?
Yes, Mr. Chairman. I'm just trying to understand does this reference back to the vital public service? So it just references back to the definition 28 through 31, is the way that works?
Exactly.
Yeah.
It's making sure it's in both code sections, so it's referenced in both.
Any other questions from the committee? All right, on the amendment, all those in favor of the amendment, please raise your hand. Senator Parent.
Sorry.
It's unanimous. All right. Now back to the underlying motion to pass now as amended. All those in favor of the motion, please raise your hand. It is unanimous. Who is carrying this bill?
Chairman Cowsert's carrying.
Chairman Cowsert. Okay. Thank you. And while you're there, let's go ahead and get your other bill done so we can get you back across the street.
Thank you very much.
Give us a second to get there. House Bill 220 a little further down your folders, we are working off of LC 442278S. And I will let you take it away.
Thank you, Mr. Chairman. Members of the committee, this is House Bill 220, and the chairman correctly recited the committee substitute we're working off of. This bill makes revisions to the Georgia Condominium Act and the Georgia Property Owners Association Act. So we're talking about that favorite topic up here of homeowners associations, the much loved, beloved by all institution. But I believe this bill actually will address in a positive way concerns many people have about HOAs and condominium owners associations. It's in response to a case from the Court of Appeals called Deer Lake Homeowners Association versus Brown. It was a 2021 case. Cert was not denied until earlier this year, so it became a final opinion. And it's an absolutely correct opinion legally. The court said that a homeowners association could not get an injunction or an order to allow them to go onto property to cure the allegedly defective item until they first utilize their legal remedies. And that's a standard proposition of law and of law of equity, which includes injunctions, things that aren't just an order to pay money, but an order to actually go do something or not do something. So it was a correct decision, but the results in the context of homeowners association, I think for most people is somewhat grotesque because most of the condominium covenants allow the HOA to utilize self-help and to go onto your property and remedy the allegedly non-conforming or defective condition. Well, I think HOAs have found that when they do that without law enforcement present, they sometimes get shot. So they would rather not go onto your property before you've had any opportunity to be heard by a neutral third party. So what the bill would do is provide that the HOA does not have to utilize a legal remedy before they can apply to a court to get an order allowing them to exercise whatever remedies they have. The reason for that is if they get the order, they can then have a sheriff present to make sure everyone's safe. And they also, at that point, have afforded the homeowner a hearing before a judge, so a judge can assess the reasonableness and the appropriateness and just the validity of the HOA's interpretation of its own condominium or homeowners association's covenants, and the reasonableness of all the fees and the fines and whatever they're trying to recover from the owner. So this actually, we believe, while it is in some sense attempting to ensure that we're not hindered by that ruling, it actually, I think, increases the rights of the homeowner and increases the opportunity for the homeowner to be heard. We also added, and part of the reason there's a substitute is after the bill was filed, the Realtors Association asked that we make some amendments, and we did that by further increasing the rights of the homeowner. The homeowner is now entitled to notice and a right to cure, basically, before the HOA can even file suit. So I think it just ensures the homeowner's got notice, that the homeowner has due process, and then we're ensuring that before anything happens on the homeowner's property, they've got a chance to present their case to a judge and let a judge rule on it. So that's basically the bill. It's condominium and homeowners associations. We're basically making the same changes, Mr. Chairman, and then there's a sort of a catch-all code section that deals with associations that aren't formed under either act, and so that's why we have that one in there as well.
Okay, you have some questions from the committee. Senator Setzler?
How do attorney's fees work in this?
Well, they're able under most, I think under law and under most covenants, to recover attorney's fees if they're reasonable. So they would have to make, and as you're probably aware, in any case in which fees are sought, a showing has to be made of the reasonableness of the rate and the amount of the fees, and the court has some discretion to oversee that process. So it doesn't really change existing law on that issue.
The reason I'm asking, this is not an area I have great expertise, but I mean, if you have the cure period, I think it's helpful. It's for lots of reasons. I know sometimes there's certain contexts, and I couldn't name them, that you have to have an ante litem notice before you're actually able to pursue attorney's fees. Is this consistent with that? I mean, do we? And I like the balance you're striking. I'm just asking the question: if I'm a homeowner that's maybe a little less compliant, and they exercise this, and I don't cure, am I in for $1,500 to $5,000 of attorney's fees for what could have been an underlying fine of much less than that?
Well, again, I think some of that's going to depend on the exact terms of the covenants, but generally, there is going to be a claim for attorney's fees that the court will have to assess the reasonableness of. So to your example, I think the court would consider whether under the circumstances that number was reasonable given the area in which the enforcement is sought and given the prevailing rate and given what services were actually provided.
I mean, I would think that, you know, people that do work for HOAs, it wouldn't be unreasonable for someone to ask $300-400 an hour for attorney's fees. That's kind of going rate for principal attorneys in a smaller firm like that. But I mean, and my guess is it's going to take some hours to go through this and make the filings and prepare. Is the effect of this going to be, in essence, a $3,000, $4,000, $5,000 hit at a minimum? And I just want to be mindful of that. I don't know how we want to strike that.
Can I help? A question on that. So this is injunctive relief, and I don't think there's anything in your bill that makes this different from any other injunctive relief case when it comes to attorney's fees. I guess the question would be, of the two ways, in my understanding, that someone could get attorney's fees on a civil action, at least this kind of case, I would think the question would be whether you're under the OCGA 9-15-14 provisions where bad faith is required, somebody being stubbornly litigious, which is a little different, or I think his question may be, would you fall into the contractual attorney's fees provision? I'm not sure if you're familiar with that area of law enough to answer that, and I don't know the answer either, which I think is 13.611.
Something like that, Mr. Chairman.
13.1. That's 13.111. And so what I don't know the answer to, because I'm not telling you the answer, I don't know, is whether suing for injunctive relief based on covenants is considered a contracts claim, where you could make a contractual claim for attorney's fees, which would be based on whether your contract says you're liable for reasonable attorney's fees. I don't know the answer to that. I don't know if somebody in the room does. My thought is it wouldn't under just an injunctive relief case, but I don't know the answer.
Mr. Chairman, I'm not sure if y'all allow phone a friend here.
We always love phone a friends.
I do. Let me
Introduce yourself, if you will.
Hi, I'm Lanier Coulter. I am a community association attorney. Been doing it for over 20 years. I'm here on behalf of the Community Association Institute National. So at the fundamental level of your question on the attorney's fees, under the Georgia Condominium Act and the Georgia Property Owners Association Act, there is statutory language permitting reasonable attorney's fees. So it would be essentially contractual, even for injunctive relief. I've been litigating cases all of those 20 years. Judges ask a lot of questions. They will determine whether they deem them reasonable in every case that we file. And this won't change that in any way.
You're holding. All right, go.
And I'm not, this isn't quibbling about, attorneys running up the cost. It takes time the workers worth their wages. It takes time to do these cases. If you're brought into a case, I'm not quibbling over rates, I'm not quibbling over hours, that's all reasonable. The question is, should the standard be more of a, Mr. Chair, was it stubborn and litigious?
Yeah.
Is that the standard, or is it again, if it's in the, I can't imagine a set of covenants that don't say, if you don't follow the covenants, you're subject to pay attorney's fees. I mean, that's got to be in the covenants. If I were an HOA president, I would want that there. The question is, what is the threshold at which, this is gonna, in essence, or at least functionally have the effect of being a $3,000 to $5,000 hit on somebody if they don't do this. I just want to be mindful of that. And if they're not in compliance, but nor are they just putting up this long time resistance, does that give rise to a multi-$1,000 hit? I just balance.
And I think, just being candid, the Deer Lake case issue, prior to Deer Lake, there were countless injunctive relief HOA lawsuits filed. The Deer Lake case created the issue in our world, especially after the shooting in Buckhead, of, are you telling associations they have to enter someone's home, go replace their roof, put lives in jeopardy without getting a court order first? And so we're trying to balance out both ends of the spectrum there, sir. And I think that question on attorney's fees will exist for judges before Deer Lake and after Deer Lake the exact same way.
But if the senator from the 37th doesn't cut his grass, and they come in and decide to cut my grass for me, you know, and or before they do, they've got to go through this process. Heaven forbid. Maybe I can get my grass to grow better, but
I would like to think they would mow the grass without incurring the attorney's fees.
but you contemplate these things. I just wanted to ask
Sure.
the committee is what's the second order effect of this, and or are we getting into because this is certainly going to empower HOAs with non-compliant members to be able to go get these rulings in court, which I think is an appropriate remedy rather than going on their property. It's just, if that's going to carry with it naturally, just structurally by virtue of filing the motions, that's going to be a $3,000 or $4,000 effort, which it may be. Is that going to create that kind of hammer?
And correct me if I'm wrong, but the bill doesn't necessarily change anything with regard to the law of that issue. That's already, I think, an issue. And when people buy property in a subdivision with these covenants, they're buying with knowledge of that. It's effectively as if they'd signed a contract. So I don't believe that the change that's being enacted by HB 220 would exacerbate that issue. Frankly, it should make the process a little more efficient. And to the extent you're asking if the notice and right to cure increases the cost, I suppose that depends on whether the HOA just handles that themselves or whether they retain counsel to draft the letter. But I would not think that would appreciably increase those costs in that circumstance.
Is it your understanding that the notice that you have to give under existing law, but it's also cited in the bill, would that notice include the enforcement of the attorney's fees provision?
Our letters would absolutely, I can't speak for every CA law firm, but typically they always note, hey, if you don't take corrective action, we can pursue you for all attorney's fees incurred.
Do you have to give that notice by law? I know you do it. There's obviously a good reason to do it. You scare people also to try to avoid a lawsuit, but do you have to give it by law, is your understanding?
Under most documents, you have to give it by contract, by that declaration.
Right.
It says you got to give them notice and certain types of notice. And just so we're clear, the statute gives notice if the documents are silent. Most documents have a very specific certified, 14-day, maybe a 10-day. But in case they don't, we added that in the statute just as was pointed out to address some concerns raised.
You have another question from Senator Hatchett?
Thank you, Mr. Chair. Just to understand exactly what this is doing, I'm assuming now, before you can file for injunctive relief, you have to exhaust all other remedies.
Prior to Deer Lake, you never had to, and judges gave us injunctive relief without trying self-help in numerous cases all over the state of Georgia. The Deer Lake case created this issue, and candidly, every firm I know of has still filed and gotten injunctive relief despite, at some level, the Deer Lake case, but it is starting to come up as questions since cert was denied, and we want to go ahead and make it clear we don't have to exhaust every remedy before seeking injunctive relief because it can create some serious issues with personal safety concerns.
So does this codify that case? Is that
it actually it's the opposite of
Okay,
codifying the
that's what I'm
case.
at. That's
Yeah,
what it
it's
sounds
the
like.
opposite. It's saying no, we don't have to do every remedy before asking for injunctive relief. We don't have to come onto your property and try to replace your roof before we go get a court
or
order.
cut my grass before?
But just so everybody knows, cutting your grass, some of those things are actually done by associations as self-help versus incurring litigation expenses. We're more concerned with things that you can't get on and off the property while someone's at their day job and put people at risk.
I got you. Okay, thank you.
Yeah, this is just a policy question of do we want them to go the injunctive relief route instead of looking at the self-help remedies? That's a policy question we have to answer with the bill. Any other questions from the committee? All right, no one else signed up to speak on the bill. What's the pleasure of the committee?
I'd like to make a motion to do pass, Mr. Chairman.
We have a motion to do pass by Senator Watson. Do we have a second? Second from Senator Hatchett. Any discussion? All those in favor of the motion to pass, please raise your hand. You voting yes?
Yeah.
Yeah. It's unanimous. Who is carrying the bill in the Senate?
I believe a certain Senate Judiciary chairman.
Okay. All right. All right, that's all.
He's a nice guy, I'm sure you
Are those all the bills you have in our committee? You still have more?
I still have more, Mr. Chairman. I look forward to seeing you again sometime.
All right, hopefully so. If not next year, always, right?
Thank you
All right,
very
well, get
much.
back across the street. Ain't they're calling for you?
Thank you. I
All right,
appreciate y'all.
thank you. All right, we'll go back on the agenda to House Bill 302. Representative Franklin, and give us just a second. We are working off your S passed in the House, LC 480815. All right, floor is yours.
That's correct. Thank you, Mr. Chairman, members of the committee. So this bill amends the code in section 16-5-94 relating to protective orders, and it gives the judge the discretion at the time of issuance to make that order a temporary or permanent at that time. There's actually two codes that are involved in this, 16-5-90, and it already has that language super clear in that one. This bill just makes it super clear in 16-5-94. And the reason why this came about was there was, the more I dug into it, there was a lot of victims that was coming up before these protective orders, and they were getting a 12 months or 3 months, 6 months, and they'd have to come back to face their accuser at a later date. And it was a hardship for the court. It was a hardship for the accused. It was a hardship for the victim in it. And this just makes it crystal clear for the judge that if he sees the need, that he at his discretion, he could give that and make it a permanent order.
All right, so the existing code already says under the stalking TPOs that after a hearing, this is not the ex parte order, I'm assuming, but after the hearing, a judge can issue several different types of orders, including a permanent or temporary order, and you're just codifying that in the other part of that code where it actually talks about how what the order is going to be. Is that correct?
That's correct. Yes, sir.
And when it says permanent basis, is there actually a time limit on permanent basis, or is that really permanent?
You know, I'm not an attorney. I don't know. That's the first time I've had that question. I would assume that it would be up to, permanent, but I'm not sure.
Yeah, I think it's 3 years. Is that right? Is he getting some nods? I think a permanent is actually 3 years. And the other question is does the bill, again, it's not really changing current law, but if somebody believes that a permanent TPO should be amended and lifted, they have the ability to go back and petition to have that permanent TPO removed?
Yes, sir. From the advice I was given by other attorneys, that the judge can do that at any time, and then if the victim so wants to reverse it, he or she just has to ask for it, and it could be done.
Your bill doesn't change any of that?
No, sir.
Okay. Any questions from the committee? No one signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Jones. Is there a second? Second from Senator Rett. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
I believe it's Senator Ben Watson.
All right.
Correct.
Senator Watson. All right. Thank you, Representative.
Thank you, sir.
Appreciate you. All right, Chairman Smith, you're next on the agenda, House Bill 126. And on this one, we do have a committee substitute we're working off of. And so we are on LC 480934S. And I will give you the floor. And of course, let us know the changes in the substitute versus what passed in the House.
Yes, sir. Thank you, Mr. Chairman, members of the committee. Good morning. Good to be with y'all. So HB 126, which passed the House overwhelmingly, this is going to fix our tangled up mess of post-conviction litigation process. The crux of what was added additionally, I'll start with the last section here, Part 3. It concerns the withdrawal of a guilty plea. And so you'll look at this process. A lot of times a defendant, whenever they plea, they'll be up against a very short deadline to withdraw that plea. I mean, the very next day could be the end of that term of court in which they just had submitted their plea. So thanks for the Pro Tem's office and their staff, for their staff attorneys, for helping us with the fix to this. We negotiated to where a defendant would have 30 days after the entry of that judgment or within the term of court So you would have until the end of that term of court, whichever is later. That way, we provided those defendants with plenty of time in case, for instance, they were coerced into the plea. I've seen that too many times, and I think that's a great addition. The next section there, this is going to actually make sure that, and this is, excuse me, Mr. Chairman, this is going to be dealing with final judgments. What you'll see a lot of times is that a defendant, if they take a guilty plea and or verdict is reached, that some charges will be dead docketed. This more so happens in plea situations, though. So they'll plead guilty to certain charges, and then they'll just dead docket the other counts. Well, those dead docket accounts, they just stay there forever until Lord Jesus calls us all home. So this is going to provide a way for them to actually get rid of those charges. Section 3 here, this is dealing with the filing for a motion for new trial. And real quickly, this is going to reinstate the meaningful access to request this post-conviction review from the court. It provides a finite time frame, still while keeping the consent of the state to this and making sure that they at least have their shot. They do have habeas in addition to this, but for some reason they had to exhaust habeas. This would still provide them with a way to file a motion for new trial. It's an extraordinary situation. Very few cases are actually successful in even being granted this motion for a hearing, much less having the motion granted. So anyways, Mr. Chairman, in short, that's the change to the bill, and stand for any questions.
Are any questions for Chairman Smith? All right. One person or two people signed up to speak on the bill, Jill Travis and Brandon Bullard with Georgia Association of Criminal Defense Lawyers, but they're in favor and they're here for any questions. Is that?
Yeah, just for questions and just a little clarification. Section 1 of the bill is only for trials. It's not for guilty pleas.
Section 1 of the bill is only for trials and not for guilty pleas, she says. All right. Any questions for Ms. Travis and Mr. Bullard? All right, thank you. What is the pleasure of the committee?
Second.
We have a motion to pass from Floor Leader Hatchett, a second.
I'm on it.
Senator Parent, any discussion? All those in favor of the motion to pass by committee substitute, please say aye. Aye. Any opposed? It is unanimous. And who is carrying this in the, okay, is that me? Okay.
Thank you, Mr. Chairman.
I probably already said yes and don't remember it, so.
Yes, sir. Yes, sir.
All
I
right.
just figured we might trade one out. I'll
Happy
carry
to
one
do
of
it,
yours.
Mr. Chairman. Thank you.
Thank you, Mr. Chairman. And by the way, our committee is passing out Senate bills, so just wanted to let y'all know we're doing our part in Judy non-civil.
All right, you keep working now.
Yes,
okay.
sir.
We'll keep doing the same.
Thank y'all.
All right, thank you. Next on the agenda, House Bill 543. Representative Reeves, one of his 10 bills that he passed out of the House this year. You must be everybody's floor leader over there. We are working off of LC 44227-8S. Is that correct?
Chairman Strickland, I actually have LC 491335.
Yeah, you're right. I read the wrong one.
All right.
So LC 491335, this is as passed by the House, right?
Yes, Mr. Chairman and members of the committee, it's great to be back in Senate Judiciary Committee to present House Bill 543. This bill amends Code Section 15-12-122 in one way. Currently, the dollar threshold for a six-person jury in state court is $25,000. This raises it to $100,000. The statute has been around since the 1800s. I believe the dollar figure started coming in the 1970s. It's moved from $5,000 to $10,000. Back in 2002, it was raised to $25,000. The Judicial Council of Georgia, they're represented today by Bob Ray and Tracy Mason. They initiated this change. It's been reviewed by the State Bar of Georgia's Advisory Committee on Legislation. I have with me today State Court Judge Al Wong, who has worked on this from start to finish and can talk about some of the deliberations. It was widely publicized to plaintiff attorneys, defense attorneys. We have a representative from State Farm here today who's in support of the bill. But just the mechanics of the current law, if you have a suit for damages in state court, and it's not superior court, it's just state court, if you demand a jury trial and your claim is $25,000 or less, you were headed to a 6-person jury trial. If your claim is above $25,000, you can demand a jury trial for with 12 jurors. This bill would increase that to $100,000, the threshold. And turn it over to the committee for questions, unless Judge Wong would like to add about the process.
Happy to answer any questions that you have.
All right, thank you, Judge Wong. Any questions from the committee for the author or Judge Wong? Senator Cowsett.
Judge, good to see you here. My understanding of the process was that you had kind of a committee that met over the summer, spring, and you reached out to a number of us to kind of
Yes.
get input.
Yes, sir.
And that committee seemed to be okay with this.
Yes, sir.
I don't believe that Georgia trial lawyers or Georgia defense lawyers have taken an official position on it as far as support, although they were represented in your committee and had an opportunity for input.
I'm not sure that's correct, Senator. I met with, painstakingly make sure the leadership of both organizations were in our committee meetings. In fact, it was GTLA, GDLA, and ABOTA, the Board of Trial Advocates, which comprise of both plaintiff and defense lawyers. On the defense side, on the Georgia Defense Lawyers Association, we had Ashley Rice, Tracy McConnell, Dave Nelson, Sally Aiken, Dart Meadows, the president. All of them were in the loop of this. We met over the summer at least 3 to 5 times. You know, I don't want to get into the sausage making, but as you can imagine, the negotiation that was back and forth. We did some very interesting survey with the mediation services. The cases that settled between 50 to 100,000 and from 100 to 150,000 is 2% variance. So very small. So, and the way we came to the threshold of the 100 was looking, you know, one side wants more, one side wants less. And State Farm was totally supportive of the 100, and that was what was agreed upon. Give you a little legislative history of this bill. It started in 1975 for superior courts. Any trials of 5,000 or less was tried with a jury of 6. In '83, the Georgia Constitution was amended. In the Constitution, Article 1, Section 1, Paragraph 11, it is specifically stated all superior court trials have to be with a jury of 12, except in misdemeanor cases, and that there should be not less than 6 jurors in courts of limited jurisdiction, state courts. So in '83, that knocked Superior Court out of the game. In '85, the statute was amended, raising from 5,000 to 10,000. In 2002, it was raised to 25,000, and it's been at 25,000 since that time, over 22 years. So we just need to make an adjustment to accommodate, you know, what is real life litigation out there, because this is not just tort cases. This is commercial cases, contract, dispossessory, hammer and nail cases, look under the hood cases, all of those kind of cases. We have, as you know, coming out of COVID, we've got a huge, huge caseload backlog. And nobody goes to trial and settle these cases unless it's put on the calendar. And if they know they don't have to go to trial, it won't go away. So we need some help. And this is, I think, one very reasonable way to resolve this. You know, another thing that the Chief Justice talked about the resources that we had at his state of the judiciary. What he did not talk about, and what I hope you will understand, the burden on the citizens. I mean, the ability to get jurors in the courthouse, that's a huge challenge right now. So we would really appreciate if you would consider this. I think this is a reasonable measure. I know you're not particularly fond of it, but we've vetted this. We've talked to the Judicial Council. Justice Peterson looked under the hood hard on this one, and it passed there. It passed the state bar, have all the bar support, have the carrier support. So we would seriously ask you to consider passing this legislation.
I have a partner who's on the board of directors of Georgia Defense Lawyers, and they had a board meeting this fall to consider this.
Yes, sir.
And could not reach consensus. So they reached out to the membership through email asking for our input.
Yes.
And still didn't get consensus support for this. And since then, I've been getting pounded with emails and questions, particularly from the defense bar, but also some plaintiffs' lawyers saying they think this number was too high. And they've raised a couple of other questions, Mr. Chairman, if I could ask just for input, that they need a little clarification. Because at common law, we all had a right to 12-person jury. That was put in our Constitution, as you pointed out, in '83, with the minimum exceptions of small claims. They believe that it was raised to $25,000 in conjunction with the minimum insurance limits increasing, so that a plaintiff would be incented to agree to a 6-person jury, since that was all the money available anyway through insurance. A defendant would be incented because it would protect them from an excess verdict,
Sure.
you know. So it made less of an impact on them to have less than 12 people under those circumstances. But those limits haven't been raised, and this is now quadrupling what this jurisdictional limit is.
May I answer?
So one question then is,
Yes, sir.
can a verdict be higher than this amount? The way it reads is a claim for damages greater than. You know, in our complaints, we may just put, you know, a nebulous amount for pain and suffering, or you might list your medical expenses or less than that. But where in this does it prevent the verdict from being higher than the $100,000? Or is that by we stipulate or agree in many of the trials?
Sure. First of all, great question. If a verdict comes back for more than 100, it's capped at 100. The judge just reduces it down to the stipulated amount. If you cap it, you can't get any more than that.
So does this statute cap it, though, or
Yes,
is
sir.
that by stipulation?
Yes, sir. Because if the defense, so this is the same question Justice Peterson asked us in the legislative committee. So what happens when the defense wants a 12-person jury trial? Well, the answer is no plaintiff is going to agree to cap damages. So it has to be by agreement. Once there is an agreement, the verdict comes back more than 100, the judge issues a remitter, enters judgment for the amount as agreed upon, not a penny more.
Senator Cowsett, I would respond. The pretrial order, in addition to the complaint, that would be a time that the plaintiff makes clear what their claim is going to be at trial, and if they go to trial and request more than their claim, they're going to be in legal trouble, subject to mistrial. And then also, as Judge Wong pointed out, if the plaintiff asks for $100,000 and the jury gives them $250,000, that would be subject to post-trial motions on point to get the verdict to conform to the claim or the judgment.
Pretrial orders are not required, and there's an awful lot of courts outside of the metro area don't even have a pretrial conference unless it's on request, you know.
That's a great point, too, Senator. There's only 72 state courts. We have 159 counties. So the bulk of these cases are only in what we're talking about in state courts, so in the 72 counties. Everything else in Superior Court. is tried with a jury of 12, whether it's $500 or $500,000. So it only affects a very small universe of state court cases.
Yeah.
And for those who do not have pretrial orders or no pretrial conference and just come in and try the case, well, there is not an agreement to cap it at 100. So you'd be trying it with jury of 12 anyways.
What I'm seeing is a great majority now of civil cases are being filed in state courts in the counties that they have them. And so I think this is going to impact an awful lot of cases, and that's why I'm troubled. Last question, and I'll leave you alone, is
No, please
I've had
don't.
one of the pushbacks I've had is that does this potentially reduce the racial diversity of the juries? If you're selecting from a smaller group out of your jury veneer, doesn't that create the possibility of less diversity or representation by minorities in a jury panel?
I don't think so, sir, because jury panels are selected based on, multiple factors. We now have very sophisticated jury pool selection system where diversity and race and gender and all of those factors are included. So when you have a panel of 12 rather than a 24, it's just proportionate to what's already in the pool. So I don't think that would affect it at all. It's not like we're going to pick 6 of this or 6 of that. It's the whole pool, it's just proportionately reduced.
A question from Senator Hatchett.
Thank you, Mr. Chairman. Based on something that Senator Cowsert said a second ago about the limits being 25,000 and that perhaps coinciding with the minimum limits that we see in car insurance policies right now, is it time to raise the minimum limits for car insurance?
That's beyond my pay grade.
Well, do you, I guess, in all seriousness, was this number set to coincide with those limits?
I think there's some truth to that, yes, sir. And so the reality of what's happening today, you still have a batch of compliance with statutory minimum coverage of 25.
Mm-hmm.
But most of the policy I see, and I think the senator will agree, that it's like in the 30s, 50s, and 50s, 100, 50/100. So there's minimum policy of 25, but we're also talking about a lot of these cases that we're dealing with are in the 30, 50, that range. So I know, for example, taxi cabs still have the 25,000 minimum coverage. So is it adequate? Probably not for me to say.
And Mr. Chairman, if I can, I'm just, if that 25,000 was set based on the minimum limits in the state for car insurance, I mean, going from 25 to 100 is a big jump when the minimum limits are still at 25. I guess, do you think we should raise the limits to coincide with this 6-person jury? And if so, is that something we could do in this bill?
I think that's a little bit putting the cart before the horse, or driving it the other way. So what happens is, I think the point we have to make is whether it's at 25 or at 100, the defense never has to agree, never. In that case, it's a 12-person jury trial, period. And as a matter of reality, no plaintiff will agree to cap at 25 or 100 and if they want a 12-person jury trial. So it's been 22 years since we adjusted this number. So I think it's really a needed process. It will really help state court cases. Because, if you try cases, you put it on a calendar, you got to have a jury of 12 before you can go to trial. It'll never go off the docket.
Mm-hmm. Okay, thank you.
Thank you.
And for the committee's sake, the House members are heading back across the street. They're about to vote on a bill, and so Matt Representative Reeves had to go back across the street. Before we move on, are there any other questions for Judge Wong? All right, we have one other person out to speak. I'm going to go ahead and have you, Mr. Potter, if you want to come forward, go ahead and speak on this bill.
Thank you, Chairman. Members of the committee, I'm Bobby Potter, and I'm here today on behalf of State Farm. I participated in a couple of Zoom calls with Judge Wong after the committee process. There was a State Farm lawyer engaged in his committee process. I'm sure many of these questions that were asked were discussed during that process. Probably not the question raised by Senator Hatchett. But I'm here to voice support for that measure as presented. At that number could be less. I think State Farm certainly resisted it being higher, mostly in regard to judicial efficiency and not so much a tick for tack on one side or the other, GTLA versus GDLA. And I gather there may be some conflict within GDLA about how that works. But I'm here to voice support for that. The second thing I would say, just because it was been raised, Senator Hatchett, obviously that is a much larger discussion about minimum limits, availability, affordability, what drives that, what drives the uninsured motorist out from availability. So that's a huge discussion separate from how you resolve these cases.
Are there any questions from the committee for Mr. Potter? All right, what we're going to do is we're going to hold on this bill until Representative Reeves gets back over. So if y'all are able to sit tight for a little bit, we have until 12 to finish the committee, but we have another bill we can move on that Senator Sessler is going to present because it's a substitute. And so we'll go down the agenda and let Senator Sessler, if you want to come down.
Thank you, Mr. Chairman.
Yeah,
members
thank you,
of the
Judge.
committee.
Like I said, if you can sit tight, we'll come
Yes,
back
sir.
on this bill
Yes,
and
sir.
discuss.
I'll be right here. Thank you.
And so we're going to go to House Bill 204, which I said is a committee substitute that Senator Sessler, we're working off of LC 4722445S. And Senator, if you, I'll let you have the floor.
Thank you, Mr. Chair, members of the committee. Bring before you today House Bill 204. It's a bill that does two things. And I've got with me the representative of the Municipal Court of Hiram. I'm going to let him
Good morning. My name is Jason James. I'm the court administrator and chief clerk for the city of Hiram, Georgia.
HB 204 does two things. It creates a council of municipal court clerks. As we know, in Georgia, there are 389 active municipal courts. Some municipal courts are busy, beehives of activity. Atlanta Municipal Court is certainly that. Others actually meet as infrequently as every other month. I know I've been in and around some of my work with small cities in Georgia. The same person that's accepting payments for water bills is at 4:30 when they close down the city. They're the clerk of the municipal court. The duties are vast, and they have the same obligations that under law that large municipal courts have. And the goal here is to create essentially a council that allows municipal courts to have professional training, standardization, and actually receive funds. It would be only subject to state appropriations if there were any. Doesn't require any, but really allows them to receive federal dollars for training. And again, we have standardization across the 389 municipal courts in our state. And again, the goal is to professionalize the operations of courts and records across our very small communities so they can function in an increasingly professionalized way. That's the first component of the bill. The second component of the bill, Mr. Chairman, is not new to the Senate. What it does is it clarifies in law two things. First, that it's only the legislature that has the power to apportion districts for county commissions. County commissions have some home rule powers, they're all subject to acts of General Assembly, and never before have county commissions been able to reapportion themselves. We do have a case that's pending right now, a county commission seeking to reapportion itself. This clarifies that only the General Assembly has the power to apportion for county commissions, but it also adds in an amendment, which I will refer to, which had this come to the floor on crossover day, we just ran out of time, what I would refer to as the Setzler Rhett-Tillery Amendment, which is Section 4 of the bill, which clarifies that anybody who is in a 4-year term, whether it's in a city council seat, county commission seat, any seat that's a 4-year term, if reapportionment happens during that term, they are not removed from their seat by virtue of their district lines changing. They could serve out that term in its completion. There is nothing in statute that clarifies that, and there's case law that's sort of on both sides of that question in the state, so it clarifies once and for all that no one can be removed from their seat. I think that's a good clarity for us to provide in the law as we do this, that the reapportionment process, though folks can't control the lines, that they should be able to serve out their 4-year terms. That's what Section 2 of the bill does. Glad to take questions.
All right, going back to the first part of the bill, it's my understanding, based on talking with the House sponsor, and Mr. James, maybe you could clarify this, that setting up this council will assist with training and also potentially assist with some grants as well. Is that part of the reason we want to get that set up?
Yes, absolutely. And currently, I would just say that 36-3213 requires that only the chief clerk attends training. And so that's one of the big parts is, as you know, city government looks at budgets and decides training for the employees, that we're wanting to make sure that everybody in the court has access to training.
All right. You have a question from Senator Parent?
Thank you so much. Question's actually on the other part that doesn't concern you. So I'm assuming this deals with, and this bill hasn't been before this committee, this deals with the redistricting litigation in Cobb County and Jericho Richardson's seat, and I'm assuming that's who you're referring to in this Section 4 that should be permitted to finish her term.
Let me answer that question with two parts. First part, this is a statewide issue. We never before in Georgia have had county commissions apportion themselves to try to do that. So it provides clarity that can't be done moving forward, that only the General Assembly has the power to do that. Specifically the Cobb case that you're asking about, there was a county commissioner that very early in their term moved to a different part of their district, and the county has since asserted a home rule power that's never been contemplated in law before by any county to try to change the outcome there. What this would do would be to assure that home rule power couldn't be asserted in the future, and that any case that was ruled on subsequent to the passage of this bill, someone could not be removed from their seat. There's never been an intention from any member of our General Assembly to have somebody move from their particular seat. It's just the consequence of a move contemporaneous with the reapportioning of lines had the effect that they were outside their district. So this would, in essence, if she were in her seat at the effective date of this bill, would not be removable from her seat, which is fine with me. But there's never been a desire to do otherwise. I think it's fair to have folks serve out their 4-year terms, and as it stands today, without this, the county has asserted that if the plaintiffs appeal prevail on the merits, which I think by most accounts they will, the county has asserted she will absolutely be removed from her seat, full stop. There's no way to prevent that. This would prevent that and provide clarity moving forward that counties couldn't do this again. So
there is pending litigation, I think you just said.
There's pending litigation.
On this issue.
There's pending litigation on this issue, and this would solve the question prospectively moving forward that no future claims of home rule could be exercised by county. That's correct.
So would this decide the pending litigation, or would this only be in effect going forward on other issues?
This in itself would not decide the pending litigation on the home rule claim, because that predates this. But with respect to the removal ruling, it would prevent anyone from being removed in a court ruling that happened after the date of signature of this bill.
So it does say on line 38 where the General Assembly has enacted. So you're maintaining that this would not be retroactive at all?
Yeah, we can't retroactively apply this to a home rule claim by a county that happened on October 25th of 2022. So that home rule claim will still exist, it'll still play out in the courts. This would prevent further assertions of that, but it would prevent the removal of anybody from office if that removal was ordered subsequent to the passage of this bill.
So you're saying that 102 would not, thereafter, Section 4 would not be retroactive because it has not, that issue is not settled, and if this were to come into law, then it could impact it since it's not settled, whereas the home rule has already been asserted with respect to the maps the delegation passed.
Yeah, it would not affect the home rule finding. It would affect the removal of somebody from office because they're in office now. As you know, case law is very clear in Georgia that any subsequent actions, if you were serving in office outside of the rules of your service,
Yeah, I'm sorry.
It's good. If you're serving in office outside the rules of your service, you know your actions to that date are not invalidated; they're still valid actions. So that person, until there was a finding that they were not validly in their seat, that is.
Wait, I'm sorry. Are you talking about Commissioner Jericho Richardson?
Yeah,
you keep saying they. I don't know who you're talking about.
In her case in particular.
Oh, okay, just trying to be clear.
If it's later found that she's outside of her seat and was not validly in her seat, all the actions that happen right now officially are still considered official action. That's the case law is very clear about that. And because of that, she's validly in her seat. So if this is enacted, signed into law by the governor before some subsequent removal, she wouldn't be removed. This would be a safe haven for her in particular from not being removed from her seat as long as this is signed by the governor before any court action that would remove her from her seat.
So I do have a couple more questions about that if you're willing to entertain.
Happy to.
So first of all, I take it that this was not properly thought through when the legislature took action last year because there must be issues with removing the commissioner from her seat in the middle of the term. Otherwise, why do we need to? I mean, or I don't know if there's a constitutional issue in terms of invalidating votes that were cast by Cobb County voters, and that's part of why this is coming up and also in litigation.
Now, to be clear, there is no stated the Constitution. Tier 1, Tier 2 powers of counties. Tier 2 powers of counties are the constitutional powers, other are statutory powers. It's very clear counties only have those powers that are specifically granted them by the General Assembly. And it says specifically they have no powers to do anything related to the election of commissioners. So we believe it's going to be an open shut case in court that the county does not have a home rule power.
No, but that's not what I was asking. Okay, you want to finish? Okay, yeah. That's fine. That wasn't what I was asking.
Counties do not have powers do not have home rule powers to reapportion themselves. That's going to play out in court. The issue, though, is, and this is what's been very clear by the Cobb County attorney as they've argued on behalf of the commissioner, that if this is litigated in court, they have said unambiguously, if they lose in court, the commissioner will be removed from office because the current framework under the Cobb County ordinance says you must live within your district the entire 4 years you're in office, or your service is void ab initio and you're thrown out of office. So they have said, she has said herself, if we lose the court case, I'm out of office. This provides a safe haven for her not to be turned out of office.
Well, I understand that, but my question is, there is no, I'm taking your answer to my question to be, you do not believe that there would be any kind of constitutional issue with the sort of voiding of the Cobb County voters that elected her, the voiding essentially of that term, because when the voters of Cobb County elected her, they elected her to a 4-year term.
So someone can make a constitutional claim. The only case law that's even close to being on point is a mayor in Villa Rica. They changed the city lines of the city. The mayor found themselves outside the city lines and was invalidated, couldn't serve out their term because of being outside the city. That's the only thing that doesn't specifically apply to a county commissioner. So there's nothing directly on point. But there is a case in which someone's not been able to finish their 4-year terms because they failed the residency requirement. So I think there's a high likelihood she would be turned out. Cobb County's attorneys have asserted she would be. She's asserted she would be. So they have essentially conceded the point that she'd be out of office if the court case goes forward. This provides a safe haven.
So I do have just one final one. So how will it work? Because the delegation passed maps, the General Assembly overrode the local delegation.
Is that true?
Well, I was there. I mean, fine. You may characterize it differently, but that's my memory of how it went down on the Senate floor.
To be clear, the delegation, Cobb County, there's a partisan majority in the House delegation. There's not in the Senate delegation. The Eric Allen has a 8-6 partisan majority in the House. For whatever purposes, the map was supported only by one party in the House. In the Senate, there's a 3-3 split.
Okay, that's sort of background.
But to make the point, there was not a locally passed map. The only map that passed was a map that passed through the general process. Just want to be clear about that.
So the question is, though, how will it work? Because these terms, am I wrong, would now be thrown off. So my question is, under the maps passed by the General Assembly, what is the term of that seat? And then what happens? Would there be a special election? Like if Commissioner Richardson did finish her term, would that then throw off sort of like the normal order of events of electing commissioners, and how will that work in terms of?
If House Bill 204 does not pass, and they lose the court case this summer, she'll be immediately, or she'll be turned out of her seat. Special election will be called. It'll likely be, depending on the timing, could be contemporaneous with the municipal election this November. Special election will be called of all of District 2 in Cobb County, but there'd be a void in that seat until that special election were called. This seeks to remedy that.
Thank you. Appreciate the answers.
Senator Rett.
Oh, I'm sorry. I think the Madam Chair answered my questions. I wanted to know if there was a court case pending. I think she pretty much took care of that.
All right. Senator Hatchett, do you have your button push?
Yes. Thank you, Mr. Chairman. And to the author, I know we had discussed this at a previous hearing, I believe, but I know we're applying this to county governments and redistricting. Mm-hmm. Why are we not applying it to municipal governments as well in redistricting?
Yeah. The part of the bill we apply to municipal governments is Section 4, the ability not to be turned out of office if you're in a 4-year term. It is my understanding in municipal governments that counties have been that cities have conventionally exercised home rule power to reapportion themselves. That the General Assembly does not do so. If the General Assembly does so, obviously that's going to trump what the cities do. It's my understanding that cities have, for purposes of city districts, conventionally in the past done that. So I didn't want to touch the city issue. I'm just trying to solve the county issue, which has, from time immemorial, been that counties never have had the power and have never attempted to apportion themselves. So I'm just trying to clarify that with this. I'm leaving the city issue untouched because I think it's a separate and distinct issue. No, it may be the desire of the General Assembly to do that. I'm just not trying to invoke, I'm not trying to wade into that swamp. I'm just leaving that alone.
And if I can, Mr. Chairman, follow up. So if we passed a local law, or I say, if we passed local law drawing the districts a certain way in a city in your district, and then the city went back and exercised home rule and changed those districts, you're saying currently they can do that, but you wouldn't want this bill to apply to them?
Well, this bill doesn't apply to cities. I'm not asserting that cities can override the General Assembly. It's been my understanding that cities can apportion themselves for city council districts unless the General Assembly first acts, which I think they'd be prevented from doing that because the General Assembly has spoken. I think the General Assembly's silent. It's my belief that cities can. But again, this bill was intentionally was drawn intentionally in a way to not address the city issue at all, because I don't want to create new law. I'm just trying to clarify existing law.
Okay, thank you.
Any other questions for the author? Or for the new author? Did you know your bill was this, gonna get this much talk?
I did not.
All right. Nobody else signed up to speak on the bill. What's the pleasure of the committee? We have motion to pass by Senator Hatchett.
As a member of the committee, I'll second that, Mr. Chairman.
All right, we have a second from Senator Hodges. Any discussion? All those in favor of the motion to pass by committee substitute, please raise your hand. We have 4. Opposed? We have 1. Motion carries. I'm assuming you're carrying the bill in the Senate?
Yes, sir.
All right. Thank you. All right. We will be at ease for hopefully only about 5 minutes. Let's see if we get our House members back. If you can stick around, this will make our Monday hearing a little bit shorter if there's any incentive for you, but we're going to have a hard stop at noon regardless. So if you're able, committee members, to stick around and just hold for just a minute, we can see if we can get our House members back. Thank you. And for those that are setting up for the next event, you're fine. We'll be out of here by 12. Don't worry. I know y'all got to get set up. We are going to go back. We still have a quorum. We have a quorum. We're going to go back. Representative Reeves, we completed the public testimony on your bill. We are back on House Bill 543. And so Mr. Potter spoke when you were out. Judge Wong spoke. Let me go back, though, now that you're back here. Any other questions for the author on House Bill 543? Is there anything you want to close with on this bill? Are you ready?
Thanks for letting me go vote. I appreciate you accommodating the schedule.
Let me turn your mic on. There you go. All right.
Thank you for letting me go vote. Thank you for looking over this in detail. I had the opportunity to compare notes with Chairman Gunner when I was over there. He was skeptical that there would be an appreciable amount of jury trials at the $50,000 level than there would be at 25. It hasn't been raised in over 20 years. There is a large caseload in addition to the COVID backlog. In terms of diversity, I heard from several state court judges in Gwinnett that they like this idea. They think they could get more trials done with that diverse jury pool in Gwinnett. It would double the number of trials based on the same amount of jurors. For those reasons, we would ask you to consider the work that the Judicial Council and State Bar Advisory Committee on Legislation, as well as a number of state court judges, have done. This will promote judicial economy and get a lot of cases moved at a time when it's needed.
All right. At this point, what's the pleasure of the committee? We have a motion to pass by Senator Hatchett, a second by Senator Cowsert. Any discussion? Do we have any amendments? Let me turn your mic on. Representative Cowsert. Excuse me, Senator Cowsert.
I'd like to propose an amendment to change the 100,000 to 50,000 on line 21.
All right, Senator Cowsert's proposing on line 21, changing the $100,000 figure to $50,000. Do we have a second for that amendment? A second from Senator Jones. Any discussion on that amendment? Does the author have anything you want to say on that amendment?
There's been an awful lot of time and examination at 100,000. I'll let the Senate Judiciary Committee do your work, and we'll go from there.
All right, so we're going to start the vote on the amendment. Everybody good? I understand what the amendment does. All those in favor of the amendment, please raise your hand. 1, 2, 3. We have 5 opposed. We have 1. So the amendment carries. So now, any other amendments? All right, now we're back to the underlying motion do pass now as amended. All those in favor of the motion, please raise your hand. It is unanimous. My understanding is you still need to have a conversation to confirm who's carrying this bill in the Senate. Is that right?
That's right. I'll be back in touch promptly.
Okay, thank you.
Thanks a lot, Mr. Chairman and committee. Appreciate it. I believe Representative Daniel is working on a bill on the floor.
Okay. I did tell Representative Daniel that if she did not get back, if no one objected in the committee, I could present. Senator Setzler is going to, that's much easier, is going to present, and she has given us permission unless somebody objects and wants to hear from her. If so, speak up. Senator Setzler, House Bill 298, even though, as I've been confused for some reason this year, when it says committee substitute, that's the House committee substitute. This is as passed by the House. LC 491364S. All right, the floor is yours.
Hey, Mr. Chairman, House Bill 298 simply provides that if a parent, adoptive parent, or natural or adoptive parent has a child under the age of 6 months, that can be the basis of a excusal or deferral from jury duty.
All right. Any questions for the new author of the bill? A question from Senator Hatchett.
I just want to say I like this bill. At the appropriate time, I'd love to make a motion.
I understand why you might like it. Are you going to continue to be a new parent of kids for a while, or
discussion offline?
Discussion on the record here? Okay, that's probably more appropriate. All right. Are you a representative again? You presented 2 House bills today.
That's right.
It's like old times. Any other questions? No one signed up to speak on the bill. We have a motion to pass from Senator Hatchett. Do we have a second? Second from Senator Hodges. Any discussion? All those in favor? We have discussion. Senator Cowser.
Just, it's on the draftsmanship almost. Right now, you can still claim exemption from jury service, it appears, if you have a child under 6 months and can aver that you don't have adequate child care. Why not just strike that out right there? Just strike out the part, that says you don't need adequate child care. Is that essentially what we're doing, right? Was there? I just wonder if there's a reason. I favor it.
That's right. So what essentially you're saying is, you shouldn't have to demonstrate you don't have adequate child care. Grandma can't watch the baby. If you're a parent under 6 months, child under 6 months, you have this almost by right. Okay.
Right.
Okay. Does gentleman?
I just was asking out of curiosity if there was a reason on the draftsmanship why you didn't just go that way, but.
I think there's that might give rise to a friendly amendment. Let me.
Will you state
I don't
what you
want to
said
amend
again,
it
though,
now.
Senator? Will you state what you said again? Oh,
I said, in part of this bill, let me find it. Let's put it back in my folder. Let me see a version of this. You see where on line 16 says provided further that any natural or adopted parent under age of 6 who executes an affidavit saying they're in custody is excused. Right up above here on lines 12 and 13, it already says that. I guess that's 6 years.
It's 6 years and no child care. So right now, you have 6 years if you can demonstrate you have no child care. This is essentially 6 months, period.
Got it. Okay, that makes
That's
sense
the
to me.
difference.
Thank
Okay.
you for the explanation.
all right. We had a motion to pass and a second from the committee. All those in favor of the motion, please raise your hand. It is unanimous. Did she tell you who was carrying this? She did not tell me.
I'm probably looking at the sponsor. I'm glad to carry it if I need to.
Okay, we'll get with her to confirm then. Okay, thank you. Or Senator Hatchett, we'll figure it out. All right, I saw the business we have. Thank you, everybody, for being so flexible with us today. We will meet again on Monday. I'll have an agenda out hopefully tomorrow so you can see all the bills that'll be out for Monday at our standard time of 4 o'clock or whenever they let us come meet. With that, we're adjourned.